If you are a green card holder with a spouse or child waiting to join you in the United States, what just happened in the April and May 2026 visa bulletins may be the most important immigration development you have seen in years. Not because it is a rumor, not because it is a possibility somewhere down the road, but because it is happening right now. It applies to a specific and very large group of lawful permanent residents, and the window it opens could allow families that have been separated for years to finally begin the process of reuniting on American soil. Missing this information, or misunderstanding how it works, could mean the difference between your spouse or child staying in the United States with a valid work permit while their case is processed, or being forced to wait outside the country for years with no timeline and no certainty about when that wait ends. This is not a situation where you want to find out about your options after the fact. The families who act on this correctly and quickly are the ones who benefit from it. The families who miss it or who misunderstand it are the ones who spend years separated when they did not have to be. So let us walk through exactly what changed, what it means in practical terms for your specific situation, who qualifies under the current rules, what the disqualifying factors are that people consistently overlook, and what the actual step-by-step process looks like for moving this forward. The category at the center of this is called F2A. If that term is new to you, here is a clear explanation of what it covers and why it exists as a separate category. The F2A visa category is part of the United States family-based immigration system. It specifically covers spouses and unmarried children under the age of 21 of lawful permanent residents, meaning people who hold a green card but are not yet United States citizens. This distinction between green card holders and citizens is critically important, and it is where a great deal of confusion originates. If you are a United States citizen, your immediate relatives, including your spouse, your minor children, and your parents, have access to an unlimited number of immigrant visas each year. There is no annual numerical cap on that category, which means in practice there is no waiting line based purely on visa availability. The process takes time, but it does not involve waiting for a number to become available. The situation for lawful permanent residents is fundamentally and significantly different. The F2A category, like most family-based preference categories, is subject to strict annual numerical limits set by federal law. The government allocates a fixed number of F2A visas each fiscal year, and when the total demand from applicants around the world exceeds that fixed supply, a waiting line develops. Applicants receive a priority date, which is the date their immigrant petition was properly filed, and they must then wait for that priority date to reach the front of the line before certain steps in the immigration process can be completed. In past years, that wait has stretched to many months, and in some periods to multiple years, during which time families remained separated with one spouse or parent in the United States and the other family members abroad, unable to work legally in the United States and unable to predict with any confidence when the separation would end. The April and May 2026 visa bulletins changed something significant and genuinely important about that picture for people currently in this category. To fully understand what changed and why it matters, you first need to understand how the monthly visa bulletin actually works. The State Department publishes the visa bulletin every month, and it contains two separate charts that operate entirely differently and serve distinct purposes. Confusing these two charts is one of the most common and most consequential mistakes people make when trying to navigate the family-based immigration process. The first chart is called the Dates for Filing chart. The second is called the Final Action Dates chart. These are not interchangeable. They do not communicate the same information, and treating them as if they do will lead to serious errors in how you plan, time, and execute your application strategy. The Dates for Filing chart controls one specific thing: when you are permitted to submit your immigration paperwork to United States citizenship and Immigration Services. If you are already physically present in the United States, this chart tells you whether you are currently eligible to file your adjustment of status application, your application for a work permit, and your application for advance parole, which is the travel document that allows you to leave the United States and return while your immigration case is pending. When a visa category appears as current in the dates for filing chart, it means there is no priority date cutoff preventing you from submitting those applications at this moment. You can file right now, today, assuming you meet all of the other eligibility requirements. Filing under the dates for filing chart does not mean your green card is imminent or guaranteed. It does not mean the government has approved your case or that a visa number has been allocated to you. What it means is that you are allowed to formally enter the process, submit your paperwork, and begin waiting while legally present in the United States, with interim benefits available to you. The final action dates chart governs something entirely separate and considerably more significant. This chart controls when your adjustment of status application can actually be approved and when your green card can be physically issued to you. Even if you have already successfully filed all of your paperwork under the dates for filing chart and your application has been accepted and is actively pending with the government, you cannot receive your green card until your individual priority date also becomes current in the final action dates chart. These two events, filing eligibility and final approval eligibility, are independent of each other and can be separated by a significant amount of time. The dates for filing chart opens the door to submitting paperwork and accessing interim benefits. The final action dates chart determines when the process actually concludes with a green card issued. Understanding both charts and the relationship between them is the foundation of navigating this process intelligently. Here is specifically what the April and May 2026 visa bulletins announced regarding the F2A category. The F2A category is listed as current in the dates for filing chart in both of those bulletins. What that means in direct practical terms is that eligible spouses and unmarried minor children of green card holders who are currently in the United States can file their adjustment of status application, their work permit application, and their advance parole application right now, without needing to wait for any priority date cutoff in the dates for filing chart to be reached. There is no line based on visa availability blocking them from submitting paperwork at this moment. If they are otherwise eligible, they can file today. For families that have been living with the uncertainty of this process, the real-world significance of this is hard to overstate. Consider what this filing opportunity actually changes in daily life. Without it, a spouse or child who is present in the United States in a temporary or expiring immigration status would face an extremely difficult set of choices as that status ran out. They could leave the United States and wait abroad for their priority date to become current in the final action dates chart, which could take 1 year, 2 years, or longer. During that entire period of separation, they would be unable to work in the United States, unable to build a life here, and entirely dependent on a government timeline they had no ability to influence or predict. Alternatively, they might remain in the United States past the expiration of their authorized period of stay, which creates its own serious immigration consequences, including bars to future benefits and potential enforcement actions. With the F2A category current for filing, an eligible applicant avoids that impossible choice entirely. They can file now, remain in the United States lawfully while their case is pending, obtain a work permit within months of filing, and begin working legally, apply for advance parole to preserve their ability to travel internationally if necessary, and spend what may be a multi-year waiting period physically present with their family in the United States rather than separated across an ocean. That difference in daily lived reality, being together versus being apart for years, is the practical meaning of what the visa bulletin change represents. This is also where the most important caution of this entire conversation must be stated plainly. Not everyone qualifies. The F2A category being current for filing does not mean that every spouse or child of a green card holder currently in the United States can automatically file and benefit. There are eligibility requirements for adjustment of status that exist independently of the visa bulletin, and each one of them must be satisfied before filing is appropriate. People who have filed adjustment of status applications they were not eligible to file have created legal complications significantly more difficult to resolve than the situations they were trying to escape. Understanding the eligibility requirements before taking any action is not optional. The first and most fundamental requirement is lawful entry into the United States. Adjustment of status, meaning the process of obtaining a green card without departing the country, is generally available only to people who entered the United States through a lawful inspected entry at a port of entry. This means they presented themselves to an immigration officer, their documents were reviewed, and they were formally admitted into the United States. Someone who entered the United States without going through that inspection process, regardless of how long ago it happened or what their family circumstances are, typically cannot use adjustment of status. Their path to a green card, if one exists, generally involves leaving the United States and completing the process through consular processing at a United States embassy or consulate in their home country or a third country. That is a fundamentally different process with different requirements and timelines, and the visa bulletin filing opportunity being discussed here does not change that for people who entered without inspection. The second major area of eligibility involves immigration violations and bars to adjustment of status. Several categories of prior conduct can create absolute or conditional bars to adjustment of status. Working in the United States without proper employment authorization is one common bar. Accumulating unlawful presence in the United States beyond certain thresholds and then departing can trigger multi-year bars to returning. Having previously violated the terms of a visa, such as remaining beyond the authorized period of admission, can create bars depending on the length and circumstances of the violation. Prior removal orders, voluntary departure agreements, and certain types of immigration enforcement actions can each create additional complications. Some of these bars have potential waivers or exceptions available, others do not. Determining which bars exist in a specific case and whether any relief is available requires a detailed review of that person's complete immigration history by someone qualified to analyze it. The third requirement is the existence of an approved or concurrently filed immigrant petition. The adjustment of status process cannot begin without an underlying immigrant petition, the I-130, which formally establishes and documents the qualifying family relationship between the green card holder and the family member seeking immigration benefits. If an I-130 has already been filed and approved, that petition provides the foundation for moving forward. If one has not yet been filed, it can be filed simultaneously with the adjustment of status application while the F2A category is current for filing, which is one of the meaningful practical benefits of the current situation. One additional point requires direct and unambiguous statement, because misunderstanding it has resulted in serious immigration consequences for people who received or assumed incorrect information. If you are currently outside the United States and you are considering entering on a tourist visa or any other temporary non-immigrant visa with the specific intention of filing for a green card after arrival, that is not a legitimate use of a non-immigrant visa, and it carries severe legal risk. A tourist visa is issued on the basis of the applicant representing to the United States government that their purpose is temporary visitation and that they intend to return to their home country. Obtaining that visa while concealing an actual intent to immigrate constitutes misrepresentation to the federal government. That misrepresentation is itself a ground of inadmissibility that can bar future immigration benefits, result in visa cancellation, and trigger removal proceedings. The filing opportunity created by the current visa bulletin is designed for people already lawfully present in the United States, not as a mechanism for entering the United States on a temporary visa specifically to file for permanent residence. For people who do meet the eligibility requirements, the forms involved in the simultaneous filing process are the I-130 immigrant petition, if not already approved, the I-485 adjustment of status application, the I-765 application for employment authorization, and the I-131 application for advance parole. Filing these together when the category is current for filing allows the applicant to access work authorization and travel benefits during the waiting period rather than remaining in legal limbo until final approval. The processing timeline for the work permit and advance parole is typically shorter than for the green card itself, often several months after filing. The green card cannot be issued until the priority date is current in the final action dates chart and the full adjudication process, including medical examination and any required interview, has been completed. For any green card holder who has a spouse or child eligible under the F2A category and has been hesitant to begin this process, the current filing availability represents a genuine and time-sensitive opportunity. Consulting with a qualified immigration attorney before filing anything is the most protective step available. An attorney can review the complete immigration history of the applicant, identify any potential bars or complications, determine whether adjustment of status is the appropriate path, and prepare the application package in a way that gives the case the strongest possible foundation for approval. This is Retirement Wealth Watch.